城下之盟 a treaty signed under coercion. Okay, now, welcome back. We will continue talk about the issue about financial contribution by a government. You need to know what does this stand for. USDOC, Department of Commerce, U.S. Department of Commerce, 美国商务部. And this stands for state-owned enterprises, 国有企业. And this stands for state-owned commercial banks. Public bodies under Article 1.1 of the SEM Agreement. There is a short video here, although it's not that short, but I'd like to play it for you to learn. Where's the sound? No sound. Anyway. Oh, this one.
Government or any public body within the territory. Like most treaties, the WTO Agreement on Subsidies and Countervailing Measures regulates behavior by states. Now, this is logical because the focus of the subsidies agreement is in fact on trade effects arising from government interventions that distort commercial markets. Now, the specific language in the Agreement on Subsidies and Countervailing Measures that regulates this issue of attribution is found in Article 1 of the agreement. Under Article 1, only measures in the form of financial contributions can give rise to subsidies. And as a general matter, a financial contribution may give rise to a subsidy only if it's provided by, and I quote, a government or any public body within the territory of a member. Now, I say as a general matter because there is a provision in Article 1 which you could refer to roughly as an anti-circumvention provision, which says that a financial contribution can also give rise to a subsidy if it's provided by a private body that is entrusted or directed to do so by the government. Now, usually, there's not much question about whether an entity is a government or a public body within the territory of a member. In the traditional case, the classic case, the entity in question might be a government ministry, Ministry of the Treasury. Ministry of Science might be giving grants for research and development projects. The Ministry of Agriculture might be providing some type of a subsidy for an agricultural product. Those types of cases are usually clear. There's no question the government's involved. In addition, In addition, the agreement regulates behavior not only by national governments, but also by other governments within the territory of the member. So the subsidy might be provided by a state government or a provincial government, or even, in fact, a municipal government, a county government. And in these cases, again, usually the situation is quite clear. Finally, you have a variety of government entities who are sort of clearly and explicitly tasked with performing some kind of public policy function. For example, you might have an export credit agency, which is created by an act of Congress or an act of Parliament that is assigned with certain functions, which is completely owned by the state. And whether that's a public body is usually not a question in dispute. Or you might have a development bank, a regional development bank, also created by the legislature with specific tasks assigned to it of a public policy nature. And again, usually the question as to whether there's a public body is not going to be in question. But there are situations where the question of attribution to the state can be less clear. And one which has come up relatively recently is the question of state-owned commercial enterprises. This issue emerged in a dispute that came before the WTO last year, that is 2010, I guess, that was called U.S. Definitive Anti-Dumping and Countervailing Duties on Certain Products from China. That's DS 379 if you want to look it up. Now, what are the facts in this case? First of all, the measure in question was a countervailing measure imposed by the United States on imports from China. In that case, the Department of Commerce, which is the investigating authority in anti-dumping and countervailing duty investigations in the United States, the Department of Commerce treated the provision of certain inputs by majority government-owned state enterprises as the provision of a good or service, that is, as a financial contribution. So concretely, if you imagine the producer, the exporter is a producer of rubber products or tire products. And I actually don't remember the products in question in this case. But concretely, if you imagine you have a producer of rubber products that has to purchase certain inputs, and it purchases those inputs from a state-owned enterprise, but which is a commercial enterprise. Or in addition, the other aspect of the case related to state-owned commercial banks. And here you had, again, the producer-exporter, say, of the rubber or the tire product, and that company received loans from a state-owned commercial bank. So the question in front of the Department of Commerce, and ultimately the question in front of the dispute settlement panel was, were these financial contributions, that is the provision of the goods that are being used by the downstream producer, or the provision of the loans by the government, were these financial contributions by a government or a public body within the territory of the member? Now, the Department of Commerce said in both cases yes, that the state-owned enterprises and the state-owned commercial banks were public bodies. And it was this issue which China appealed to the WTO dispute settlement system. Now, what was the answer? The answer at the panel level was that the concept of a public body within the meaning of Article 1 of the Subsidies Agreement is an entity which is controlled by the government. So the panel focused on the idea of control. And the panel reasoned that where you have control, this gives rise to a possibility that the entity in question might act for public policy purposes rather than out of commercial interest. The panel further said that majority government ownership, although not necessarily conclusive, was clear and highly indicative evidence of control. And on this basis, it found that the Department of Commerce had not erred in treating these government-owned, state-owned enterprises and commercial banks as public bodies. The appellate body, however, disagreed. The appellate body said that government control is not enough to establish that an entity is a public body. The appellate body explained that a public body must possess, and here I'm quoting, it must possess, exercise, or be vested with government authority. And it went on to explain that mere formal links between the government and the entity, such as majority ownership, are unlikely to suffice. Now, what does this mean in practice? Let's look at how the appellate body applied this legal test to the facts in question. With respect to the state-owned enterprises, that is, the companies that were providing some kind of industrial inputs to the downstream producers, the appellate body found that the Department of Commerce had erred because it did not properly find that the state-owned enterprises were public bodies precisely because it relied principally on evidence of majority ownership. But with respect to the state-owned commercial banks, the appellate body found that the Department of Commerce did not err. It found the Department of Commerce had not only evidence of majority ownership, but that it had also relied on evidence that these commercial banks were required to carry out their loan activities based upon the needs of the national economy and under the guidance of state industrial policies. And this was based upon various policy statements, legislation creating the bodies, etc. So the conclusion is, if you have a state-owned enterprise, is it a public body? It might be or it might not be. It's not enough to say that it's owned by the state, even majority ownership. Instead, you have to ask whether the state enterprise is vested with government authority. And you can look at things like the legislative basis for the creation of the entities or legislation or regulations governing their behavior as possibly relevant to that. But it's important to remember that even if you find that a state-owned enterprise is not a public body, that does not necessarily mean that its behavior is not attributable to the state. Because as I mentioned, there is sort of an anti-circumvention provision. And if you can demonstrate the state-owned enterprise or the state-owned commercial bank was entrusted or directed by the government to provide the financial contribution, then the behavior of that entity is still attributable to the state. Thank you very much.
Thank you very much. Have you understood reading? Now that professor has already explained it in English, I will explain it again in Chinese. Okay. I will explain it in Chinese to help you better understand. Because this course is bilingual course. Okay.第一组的同学注意，这是一个典型的问题啊，很重要的问题，公共机构的问题。第一步，你首先要知道谁发起了调查。美国的商务部针对的是中国的补贴，中国先有补贴行为，美国商务部就对中国的补贴行为进行调查。他说中国的国有企业、国有商业银行对企业进行了 financial contribution。好了，这是政府层面。结果，最终调查结果是认为中国存在补贴，于是对中国征收了反倾销税，还有反补贴税。中国就去 WTO 起诉，去告美国的什么呢？告美国的调查行为不符合 WTO， 还是告他的这个反倾销税、反补贴税不符合 WTO 呢？ 他是告的这2个都有，既包括他的行为调查行为，还有他的这个主要是他的调查行为调查行为，还有他采取的这些个反倾销税和反补贴税这2个东西，他就起诉了 WTO， 起诉到了 WTO， 起诉美国。然后专家组，你看这是一个第一步是这个政府的调查活动，还有这些个采取的措施。第2步就是专家组是什么观点，尤其是关于公共机构的问题。现在回忆一下，你要想构成补贴，需要满足几个条件？不是，你要想采取反补贴措施，有几个条件？首先，第一，存在补贴；第二，这个补贴造成了损害、严重损害或严重损害威胁或严重损害的阻碍，对建立新产业的严重阻碍，实质阻碍啊。第3步是存在因果关系。好，但是在这个存在补贴这第1个环节当中，有一个什么要求？有财政资助，也是3个步。第1个是有财政资助，第2个接受者真正获得了利益，第3个资助具有专项性 （specific）。好，那第1个你有财政资助，那肯定是得由政府或者公共机构。我说的第1个是公共机构的问题。那你想是财政资助是补贴，是一个政府行为，那就必须得是构成公共机构。那专家组他认为什么呢？在公共机构的问题上，专家组认为是国有企业进行的，state-owned enterprises 和国有企业商业银行 commercial bank 这2个，这都不是政府，它能构成补贴吗？有间接补贴这个概念吗？在这个 SCM 协定当中已经有规定，第2.1条规定，要想构成补贴，只能由政府或者公共机构才可以，只有这2个，别的都不行。问题的关键是，他们2个是政府吗？不是。他们2个是公共机构吗？这就是关键问题。中国认为他们2个不是公共机构，美国他已经调查结果已经有了，他肯定认为是公共机构。好，那专家组怎么认为呢？专家组认为它是公共机构。为什么？它是公共机构，为什么？因为这种企业都是你看国有 state-owned， 因为它是国有，它的所有权是谁？是国家呀，或者公共部门、政府机构是吧？因为是国有，而且还能控制标准，国有企业控制标准，政府在控制他们，所以他们做的那些个行为都是补贴。这是专家组的标准，叫控制标准 ，ownership， majority ownership， 就是主要的控制 ，majority ownership。然后上诉机构又说什么呢？上诉机构又推翻了专家组的观点，他认为控制标准是不对的。是不对的，要看这些个企业有没有得到政府的授权或者是权利。能不能行使政府权利，这是那个标准。专家组的标准是，他们这2种机构能不能行使政府权利。能不能行使政府权利，这是那标准，而不是所有权、 和控制的问题，而是到底有没有行使政府权。即便是一个私人企业，不是这个国有的哈，就是一个纯私有企业，如果你在行使，它是得到了授权，在行使政府权利，也算政府的，就像他说那个间接的行使。他私人企业只要你有政府权利，也算把你当成政府，你的行为也可以构成补贴。所以在公共机构这个问题上，第一组同学需要做的是，这是其中一个问题，你就要把我刚才讲的这个过程，你把它弄清楚。关键在哪里？在政府权利，不在所有权，不在控制，在政府权利。如果是政府权利，国有企业、国有商业银行行使政府权利可以资助；如果是私人企业，你行使政府权利也可以进行政府捐助、政府资助。所以关键标准在这里。所以最终的结果，专家组是什么结果？认为他们构成吗？你们看一下。啊，这个思路我告诉大家了，你们的作业的模式就是这个。关键的问题在于识别出那一个问题来，每个同学估计只能识别一个问题，就小问题。刚才这个视频的文本中英文的我发在群里边，我分享的那个文件就是，回头大家可以自己看一下。Okay, now let's resume back to the English language version. Okay. In the process of the investigation, the US DOC rejected the in-country private prices. In-country private prices in China as benchmarks to determine the existence and amount of the benefit. The benefit just means the good, the financial contributions. The benefit just means the financial contribution. Okay. In-country private price. The US DOC rejected China's domestic private prices. Instead, it uses the prices in the United States. Okay. And this one, the interest rates in China. The interest rates, there are loans involved made by the state-owned central commercial banks. The loans denominated, RMB denominated. The interest rates. The US DOC rejected the interest rates in China as benchmarks for calculating the benefit from RMB denominated loans from SOCBs. Okay. Another point is China challenged the US DOC's use of yearly average as opposed to daily benchmark interest rates in respect of the benchmark used for US dollar denominated loans. The panel upheld China's claim. Okay. There's another important issue. It's about the offsetting of positive benefit and the negative benefit. What does that mean? I'll give you an example. I made an investment to a specific company, his company, for example, and this company get positive benefit of, say, 10,000 RMB, for example, okay, 10,000 RMB. But this company did not get the 10,000 RMB in total. I mean, not get everything. He made a kickback. For example, 10,000 is, for example, 2,000 RMB back to the officials. Just an example. Then, what's the net? The net benefit is what? The financial contribution of net. The net benefit would be how much? $8,000? $8,000 or $6,000? $10,000 and then $2,000. The benefit, the original benefit is $10,000, right? Then there is a $2,000 kickback, for example. Then what did it get? $8,000, right? Yeah. There is an offsetting. It's not an appropriate example. Anyway, there is a positive benefit, then there is a negative benefit. You need to do the offsetting, okay? Okay, the first question is about the public, as you can see, team number 1. The first issue is about the public bodies, okay? And the second issue is regarding the benefit determinations. I mean the determination of the benefit, 利益的认定. This is the issue, okay? And the third issue is what? The benchmark, 基准利率, 基准 benchmark, used for US dollar denominated loans. Okay. The fourth issue is about what? Regionally specific. 地区专项性. For example, I'm also the governor of the Zhejiang provincial government, okay? I made a financial contribution specifically to Wenzhou city. So this is a regionally specific financial contribution. Why? Because other municipal cities, for example, Ningbo, Shaoxing, they are discriminated. Okay? This is a regionally specific financial contribution. Okay, good. The fifth issue. The class will be over at 16:40. Okay, good. Okay, the fifth issue here. There are two important conceptions I need to highlight. Okay. Look at this. Regarding China's double remedy claims, the panel agreed with the United States that the measure challenged as part of China's as such claims, as well as these claims themselves, fell outside its terms of reference, since China failed to include that measure in its request for consultations. On the merits, the panel rejected China's as-applied claims with respect to double remedies, while it found that the use of an NME methodology in an AD investigation concurrently with the imposition of countervailing duties may give rise to double remedies. The panel found that China had failed to establish the inconsistency of such a double remedy with the provisions of the ASEAN agreement upon which China relied. This paragraph, there's so much information included in this paragraph. First important thing is, what's the difference of as such claims and as applied claims? What's the difference? In Chinese, we can call it and here, in this one, in Chinese, it's called the difference between these two kinds of claims is similar to the difference between abstract administrative acts and specific or concrete administrative acts. What does that mean? Yeah, good. This one is just like an abstract administrative act. And this one is just like a concrete or specific administrative act. 它们的区别就像抽象行政行为和具体行政行为之间的区别。法规之诉意思是，我针对这个法律 ，for example， 中国制定了一项法律，版权法，这个法律的规定本身就不符合 WTO 的规定，所以其他国家针对这个来起诉中国，这就是个法规之诉。As such, as the laws like。第二个呢，是这部法律在适用的过程当中，适用这部法律的过程当中发生的行为。As applied claims， 不符合规矩，不符合 WTO 的规定。As such, this such refers to the laws, the regulations, the rules, while as applied means the application of the laws, the rules and the regulations, the application of the laws and rules, the laws and rules themselves. As such claims and as applied claims. Then let's talk about a double remedy. You noticed what's the case title? The definitive anti-dumping and countervailing duties. Two kinds of duties, right? In one same case, there are two types of duties. Do you think that's fair for China? Let's say China has made a subsidization. But you can only levy or impose countervailing duties. Why? Together with anti-dumping duties, which means you impose the duties twice for one act. That's why double remedy. Double remedy. And NME, there are so many words. NME means what? Non-market economy methodology. 非市场经济方法。You still remember when we are calculating the normal value of goods? 我们在计算产品的正常价值的时候，用哪个作为参照物来着？比较价格来着？You still remember? 如果你是一个市场经济国家，用谁的国家？用谁的才比较价格？用中国自己的，对吧？如果你是一个非市场经济国家，你要用哪个国家？第三国的可比价格 （comparable prices） right? Comparable prices in third countries. How did this double remedy arise? 这个双重救济到底怎么发生的？是这样子的，用汉语给大家解释一下。中国政府进行了补贴，美国政府来调查中国的补贴行为，因为他就是针对这个具体的补贴行为，他认为你存在补贴，所以他就征收了反补贴税，这是一层救济，当下就征收了。但是在美国把这个商品从中国进口到美国的时候，因为中国又是非市场经济，它要进行倾销的计算，它要用它的因为进口到美国来只看价格，那它就因为中国又是个非市场经济，它用第三国的价格来计算，补贴的那一部分它就不算了，它已经征收了，就算征收了。然后在计算倾销的时候，它又根据第三国的可比价格一看，又有一部分差额，它又征收了反倾销税，所以就两个就叠加起来了，两个互不干扰。但实际上对中国来讲，只有一个补贴行为，双重救济，不公平。第一个，为什么这个 as such claims 专家组不支持中国呢？因为你在磋商请求当中就没有把这个法律规定本身放到你的 terms of reference， 放到你的职权范围之内 terms of reference。 这个 terms of reference 是一个专有名词 is a technical word, means whose authority, the panel's authority, 专家组的职权范围。在成立专家组的时候，中国你根本就没有把这个 as such claims 放到你的专家组职权范围之内去，所以 fell outside its terms of reference， 所以专家组就不具有管辖权，专家组织就没有支持中国的关于这个是主张 as such claims。 关于这个呢，关于适用之诉呢，他又说中国没有怎么样，他说 China had failed to establish the inconsistency of such a double remedy with the provisions of the SCM agreement。 他说你中国依赖的这个 SCM 协定里边没有关于双重救济的问题，你不能证明美国的做法不符合 SCM 协定当中规定的双重救济的条款。这是专家组的意见。他说你中国没有证明美国的这种双重救济不符合 SCM 协定。 而你中国又是依赖这个 ICM 协定的，所以也没有支持中国的观点。但这只是专家组的这一层。上诉机构是什么意见？后边有。When we talk about the positions of the appellate body on these issues next, the week after next week. Okay? Okay, today's class is over and we will meet next time, I'm afraid. Goodbye.